Obligations, particularly kinds of obligations, and this is our part 2. We are still in pure and conditional obligations. Natapos tayo sa suspensive and resolutory conditions, and this time we will be talking about the other kinds of conditions. As to cause or origin, we classified conditions either as potestative, casual, or mixed. So ano ba itong potestative condition? When the fulfillment of the condition depends upon the will of a party to the obligation, then said condition is considered potestative. We all know that the parties to the obligation are either the creditor or the debtor. So when the fulfillment of the condition depends exclusively upon the will of the debtor, the condition is void. Basis, that is your Article 1182, first sentence. Very clear yan. Also, that also violates the principle of contract, which is Article 1308. Ano ang sinasabi ni Article 1308? The contract must bind both contracting parties. The validity or compliance cannot be left to the will of one of the parties. How about when the fulfillment depends exclusively upon the will of the creditor? This time, the condition is valid. Next is your casual condition. Ano ang casual condition? The fulfillment of the condition depends upon chance and or the will of a third person. So no longer the party to the obligation but a third person. And here, the condition is valid. Your mixed condition is a combination of potestative and casual. So when the fulfillment of the condition depends upon the will of a party to the obligation and partly upon chance and or the will of a third person, said condition is also valid. For application, let's take a look at this 2003 bar exam question. Are the following obligations valid? Why? And if they are valid, when is the obligation demandable? Number 1, if the debtor promises to pay if his son who is sick with cancer does not die within 1 year, is the obligation valid? Answer, yes, the obligation is valid. What kind of a condition is involved in number 1? That is a mixed condition. The fulfillment of the condition does not depend alone upon the will of the debtor, but also upon other factors which are outside of the control of the debtor. So, ang sinasabi dyan, if the son will not die within 1 year, the debtor will also pay. So, that is beyond his control. Number 2, if the debtor promises to pay when he becomes a lawyer, is the obligation valid? Answer, yes, the obligation is valid because that is also a mixed condition. Your becoming a lawyer does not depend alone upon your will but also upon other factors. Paano ba maging abogado? It is not only passing the bar examinations but also taking your oath and signing the roll of attorneys. Kahit pumasa ka sa bar exams, if you are not able to take your oath or sign the roll of attorneys dahil may nagreklamo sa inyo, hindi ka magiging abogado. So that is outside of your control. Number 3, if the debtor promises to pay when he likes, is the obligation valid? No, the obligation is void because that is a potestative condition that is dependent upon the will of the debtor. Ano ang sabi natin? If the potestative condition depends upon the will of the debtor, then the condition is void. Therefore, the obligation is also void. Number 4, if the debtor promises to pay as soon as he has the means to pay, what is that? Is the obligation valid? Answer, yes, the obligation is valid because that is considered by law as an obligation subject to an indefinite period as what is provided in Article 1180 and Article 1197. Article 1182, first sentence, reads as follows: when the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. So, ang tanong, do you apply this to all kinds of conditional obligations regardless of their nature? Answer, we're going to find out. So, if we talk about conditional obligation, we all know that it could be an obligation with a suspensive condition or an obligation with a resolutory condition. So in a suspensive potestative condition, if the fulfillment depends exclusively upon the will of the debtor, what did we say? The condition is void, therefore the obligation is void. But when the fulfillment depends exclusively upon the will of the creditor, the condition is valid, the obligation is also valid. How about in an obligation with a resolutory condition? If the fulfillment depends exclusively upon the will of the debtor, the condition is valid, the obligation is valid. So magkaiba. Bakit magkaiba? Parehas naman silang depends exclusively upon the will of the debtor. So we're going to study. Let's find out. Let's go back to our example. Pacquiao promised in writing to sell his Forbes Park mansion to Mocha Oson if the latter passes the bar exams in her first attempt. So this is an obligation with a suspensive condition. The suspensive condition is Mocha Oson will pass the bar exams in her first attempt. So here, who is our creditor? Our creditor is Mocha Oson. Mocha Oson is the one who can demand the fulfillment of the obligation. Next, our example of an obligation with a resolutory condition is Senator Pacquiao. He sells his Forbes Park mansion to Kuya Will with right of repurchase. The right of repurchase is your resolutory condition. So in this example, who is our debtor? Our debtor is Senator Pacquiao. So ano ang sinasabi ng batas? Ang sinasabi ng batas is the position of Senator Pacquiao when the condition is resolutory is exactly the same as the position of Mocha Oson, the creditor, when the condition is suspensive. Bakit? Because Senator Pacquiao is very much interested in the fulfillment of the resolutory condition, since it is only by such fulfillment that he can reacquire the rights which he has already vested to Kuya Will upon the constitution of the obligation. Therefore, even if the fulfillment depends exclusively upon the will of the debtor, the condition is valid, the obligation is also valid. How about when the fulfillment depends exclusively upon the will of the creditor? Here again, the condition is valid and the obligation is therefore valid. So pag pinag-uusapan mo si Article 1182, actually ang nire-refer dyan that the conditional obligation shall be void is referring to a potestative suspensive condition. That is why for the limitations of your Article 1182, take note that the rule is applicable only to a suspensive condition or an obligation with a suspensive condition. Please do not apply Article 1182 first sentence if the obligation is one with a resolutory condition. For application, let's take a look at this 2000 bar exam question number 15. Pedro promised to give his grandson a car if the latter will pass the bar exams. When his grandson passed the said examinations, Pedro refused to give the car on the ground was a purely potestative one. Question, is he correct or not? Answer, no, Pedro is not correct. Again, what is the condition here in this problem? That is, pass the bar examinations. So what kind of a condition is this? Is this a suspensive condition or a resolutory condition? Answer, this is a suspensive condition. So therefore, our problem here is an obligation with a suspensive condition. Next, who is our debtor? Pedro. Pedro is our debtor. Therefore, our creditor is the grandson. It is the grandson who can demand the fulfillment of the obligation. But ang tanong, who will fulfill the suspensive condition? Is it Pedro or the grandson? Sino ba ang magti-take ng bar exams? Sino ba ang dapat pumasa sa bar exams? Answer, the grandson. Therefore, what did we say in a potestative condition where the fulfillment of the suspensive condition depends exclusively upon the will of the creditor? The condition is valid, the obligation is also valid. But ang tanong, does the fulfillment of the suspensive condition depends exclusively upon the will of the grandson? Answer, no, because the condition here is not a pure potestative but rather a mixed condition. Kagaya ng sinabi natin, ang pagiging abogado nyo is subject to other forces outside of your control. The same also with you passing the bar exams. It does not depend alone upon your will but also upon a chance and or the will of a third person. This is also the answer of the UP Law Center. Let's repeat what we said. We said that if an obligation is subject to a suspensive condition and the fulfillment of the suspensive condition depends upon the will of the debtor, then the condition is void, the obligation is also void. But even if the fulfillment of the condition depends upon the sole will of the debtor, however, if it relates to a fulfillment of an already existing obligation, then only the condition is void and not the obligation. Meaning to say, only the condition is void, but the obligation is valid. Let's have an example para mas lalong maintindihan. Senator Pacquiao, he borrowed 10 million from Kuya Will, which is payable within 30 days. Subsequently, Senator Pacquiao, he promised to pay Kuya Will after he sells his Forbes Park mansion, to which Kuya Will agreed. So what can you determine from this example? First, the first obligation was without a condition at all. Ang original na usapan, walang condition. Senator Pacquiao only borrowed 10 million from Kuya Bill and it is payable within the period of 30 days. However, after how many days, they entered into another agreement, and this time the fulfillment of the suspensive condition depends now upon the debt, exclusively upon the will of the debtor. In this case, depends exclusively upon the will of Senator Pacquiao, whether he sells his Forbes Park mansion or not. And what did we say? Here, only the condition is void because it is a potestative suspensive condition, but not the pre-existing obligation of Pacquiao to Kuya Will. So, if we are going to apply Article 1182, take note again that the application of Article 1182 is only to an obligation with a suspensive condition, and second, you cannot apply it to a pre-existing obligation. Only to those obligations which depend for its perfection, the fulfillment of the potestative condition. 1997 bar exam question number 14. In two separate documents signed by him, Juan Valentino obligated himself each to Maria and to Perla. Months passed, but Juan never bothered to make good his promises. Maria and Perla came to consult you on whether or not they could recover on the basis of the foregoing settings. What would your legal advice be? Take note that the examiner wants you to assume the role of a lawyer. So there is a role playing in the question. So as a lawyer, what is your legal advice? Pag nakakita kayo ng ganitong kind of obligation, and the fulfillment of the condition depends upon the will of a party to the obligation, ganito dapat ang approach. First is you determine what kind of an obligation is involved. Is it an obligation with a suspensive condition or an obligation with a resolutory condition? Next, determine who will fulfill the condition. Is it the debtor or the creditor? Bakit? Kasi pag debtor ang mag-fulfill ng condition in a suspensive condition, the condition is void, the obligation is also void. As to the rest, valid na yan. Your next approach would be, ask yourself, is it a pre-existing obligation? Bakit? Kasi pag pre-existing obligation yan, even if the fulfillment of the condition depends upon the will of the debtor, that is a valid obligation. Ano ang sinabi natin? If there is a pre-existing obligation, only the condition is void, but the obligation is valid. So in this problem, going back, the first obligation of Juan Valentino is to give Maria my one and only horse when I feel like it. So here, who will fulfill the condition? It's Juan Valentino, and Juan Valentino is your debtor. Therefore, the condition is void, the obligation is also void. So if you are a lawyer, if you will be assuming the role of a lawyer, what will your advice to Maria then? Tell Maria not to go after Juan Valentino because that would be a waste of time. Next, what is the obligation of Juan Valentino to Perla? He promised or he obligated himself to pay Perla the amount of 500 pesos when I feel like it. So again, is it a suspensive condition? Answer, yes. Is the fulfillment of the suspensive condition depends exclusively upon the will of Juan Valentino, your debtor? Answer, yes. So, pag ganyan, di dapat ang sagot is the condition is void, the obligation is also void, di ba? But take note of Article 1180. Ano ang sinasabi ni Article 1180? When the debtor binds himself to pay when his means permit him to do so, the obligation is not void because it will be considered as an obligation with a period. Therefore, this is the answer of the UP Law Center. Tugma lang naman. We could classify also conditions as to possibility, possible condition versus impossible condition. So when is it a possible condition? If it is capable of realization not only according to its nature, but also according to the law, good customs, and public policy, that is a possible condition. The opposite of that is your impossible condition. What are your examples of impossible condition? Number one is if the obligation says that I will pay you if you are going to file an annulment against your husband, then that is against the public policy, against the law. So that is considered an impossible condition. Wala naman masyadong problema sa possible and impossible condition. Parang hindi naman siya masyadong tinatanong sa bar exam or hindi siya favorite topic. But I want you to take note of this. What is the effect of impossible condition to obligation, to simple or remuneratory donation, and to testamentary disposition? Kasi iba-iba ang kanyang effect. First, if it is an obligation which carries an impossible condition, the condition is void. Therefore, the obligation is also void. What is your basis? That is your Article 1183. Ano ang sinasabi ni Article 1183? Impossible conditions are those contrary to good customs or public policy or those prohibited by law shall annul the obligation which depends upon them. How about if it is attached to a simple or remuneratory donation? here, the condition is considered not imposed. Therefore, the donation is considered valid. What is your basis? That is your Article 727. Illegal or impossible conditions shall be considered as not imposed. How about in testamentary disposition? Do you consider also the condition as void? Answer, no. The condition is considered as not imposed. Therefore, the testamentary disposition is valid. Basis, that is your Article 873. Impossible conditions and those contrary to law or good customs shall be considered as not imposed, but it will not prejudice the heir even if the testator should otherwise provide. So please take note of the effect of impossible conditions to obligation, to donation, and to testamentary disposition. Other classes of condition as to divisibility, it could either be a divisible condition or an indivisible condition. So if it is susceptible of partial realization, then the condition is considered divisible. And if it is not susceptible of partial realization, then that is an indivisible condition. Next, as to the number, it could either be a conjunctive or an alternative condition. Conjunctive, if there are several conditions and all of which must be realized. Whereas in alternative, there are also several conditions but only one must be realized. As to form, it could either be an express condition where the condition is stated expressly or an implied when the condition is tacit. And as to the mode, it could either be a positive when the condition involves the performance of an act and negative condition where it involves the omission of an act. Down to our last slide, this is the doctrine of constructive fulfillment of suspensive condition. So pag tinanong kayo sa bar exams, what is the doctrine of constructive fulfillment of suspensive condition? Huwag magpanic because this is your Article 1186. Ano ang sinasabi ni Article 1186? When the obligor or the debtor voluntarily prevents the fulfillment of the condition, it shall be deemed fulfilled. But take note that for you to apply Article 1186, these are the requisites. First, the condition must be suspensive. Second, the debtor or the obligor actually prevents the fulfillment of the condition. And third is he acts voluntarily. Para lalo nating mas maintindihan, let's go back to this bar question na binasa natin. If the debtor promises to pay when he becomes a lawyer, is that obligation valid? Our answer is yes, the obligation is valid. What did we say? The condition here is a mixed condition because it does not depend alone upon the will of the debtor, but also outside but also on other factors outside the control of the debtor. But you might ask, bakit paano kung ayaw niyang mag-take ng bar exams? Paano kung ayaw niyang mag-take ng oath or mag-sign ng roll of attorneys? Therefore, it is not outside of his control. It is within the control of the debtor. But in that case, ano ang sinabi ng batas? That is your Article 1186. Because the debtor voluntarily prevents the fulfillment, therefore the condition is deemed fulfilled. This is the end of our video. Thank you very much for watching and have a good day.